We simply cannot allow people to pour into the United States undetected, undocumented, unchecked.
And complete the dang fence.
This bill that we will sign today is not a revolutionary bill.
Cast down your bucket where you are.
We come from France.
And I am, adamantly against illegal immigrants.
They're coming in by the thousands, just unbelievable.
A wall is an immorality.
Who are you rooting for?
Those masters of the universe are at it again.
They're not sending their best.
You maniac! You blew it up!
Welcome to Parsing Immigration Policy, the podcast of the Center for Immigration Studies. My name is Mark Krikorian, Executive Director of the Center. And today we're going to talk about the role that the Social Security Administration and Social Security numbers have in policing immigration, basically. There's two separate aspects of it we're going to talk about with George Fishman, our Senior Legal Fellow here at the Center. And I think the context is that we don't have a national ID card. That's something people have kind of recoiled from, and we don't have anything like that. And I don't even think we necessarily need one. But a modern society does need some kind of national ID system, an identifier, if not an actual ID card you carry around. Because, this isn't like, the song in the old sitcom Cheers where everybody knows your name. Well, in the Middle Ages, you're living in a village and everybody knew your name because nobody moved, traveled more than 5 miles from where they were born. That's not the way it is in a modern society. And so there has to be a system of national identification, whether there has a card with it or not. And for us, our system is based on the Social Security number, which at this point are now issued at birth or shortly after birth for, newborns, and, combines that with driver's licenses, state ID cards, that kind of thing. And so but the core of it is the Social Security number. And so the role of the Social Security Administration in not just the broader issue of identification, but in the places where really the rubber hits the road, which is in immigration and citizenship related matters, is central and something that we are still, in our politics kind of ambivalent and conflicted about, but it's extremely important. And so we're going to talk about a couple of aspects of that with George Fishman. George, thanks for coming on. And you talked about two different aspects of it. The first is something that was just in the news on enabling states to verify citizenship. So using Social Security numbers to do that for purposes of registering voters. And then later we'll get to the other aspect, which is what are known as no-match letters. And there the issue is employment. In other words, whether somebody's lawfully allowed to be employed in the United States and the role the Social Security Administration has in that. So why don't we start with the voter registration thing? What happened recently? What's sort of the background of this, and what is the administration proposing to do?
Well, sure. And Mark, thanks so much for having me. I should say that while I am in doubt as to whether when I retire, will ever have Social Security benefits available, Social Security, the system, the card can be used right now to benefit the nation in the two ways we're going to talk about it. And one is, just last week, United States Citizenship and Immigration Services announced that it was going to give states and localities, voting registration officials, the ability to check the Social Security numbers of people seeking to register to vote, but also people already on the voter rolls to make sure that they're really U.S. citizens. And federal elections, to vote in a federal election, you must be a U.S. citizen. It's a criminal offense to vote in a federal election if you're not a U.S. citizen. But there's the problem for years, for decades, is there's no effective, readily available mechanism for states and localities to make sure that on their voter rolls are not aliens, whether here legally or illegally, aliens who are ineligible to vote. And so USCIS indicated that was setting up the system for states and localities at no cost to the states or localities. They could check to make sure that their voters were actually legally eligible to vote in federal elections, that they're U.S. citizens. And this rang a bell with me because I think it's now 28 years ago, Representative Steve Horn, a Republican from California, introduced legislation to, in effect, do the same thing, to set up a system whereby voting officials could check their voter rolls against Social Security Administration data, against the then Immigration and Naturalization Service data, to make sure that the people on the voting rolls were, in fact, U.S. citizens. I had drafted the legislation. Steve Horn introduced it. It was actually brought to the floor of the House in 1998, and it was voted on. It received more votes. I believe it received 210 votes, 200 votes against it, but it didn't pass because it was put on the floor under the so-called suspension calendar, under which you needed it's very limited debate. You need a 2/3 vote to pass. So it got a majority of the votes, didn't pass. Leadership never brought it up again under regular order, whereby it could pass with just a majority vote. So that was that. A few years later, George Gekas, who I was working for then as chairman of the Immigration Subcommittee in the U.S. House Judiciary Committee, introduced major post 9/11 immigration reform legislation. One of the provisions was a modified version of Mr. Horn's legislation, modified in a few ways. The most important way would be it wasn't just a voluntary system set up for states and localities. It was a mandate that states and localities, for the purposes of federal elections, had to use this system to make sure that people voting in federal elections are U.S. citizens. And so that was sort of the history about it. So I was more than gratified to read the USCIS announcement. In this business, as you know, sometimes it takes decades for things to actually move forward, even after they're enacted. The Real ID identification standards for getting aboard an airplane, enacted by Congress 20 years ago, finally being implemented now. So sometimes in this business, you got to wait a long time.
That's for sure, yeah. A few questions I had on how something like this can work, because Social Security numbers, I mean, all kinds of non-citizens have Social Security numbers. Obviously, anybody with work authorization, including lots of illegal aliens, including illegal aliens who may have had work authorization and who may have been legal at one point, guest workers, for instance, or even students, were issued a Social Security number and then became illegal aliens, and the Social Security number doesn't get canceled or anything. So how would something like this work? Because if you're just checking with Social Security, all they would really be able to know is that the person the state registrar of voters is asking about, doesn't have a Social Security number or has a fake one or something. In other words, if he were an illegal, it could root those kind of people out, some of them. But lawful aliens who are not allowed to vote but are otherwise lawfully here and have a Social Security number, it wouldn't identify them. So it would require kind of a two-step check. Isn't that correct?
Mark, that's an excellent question. And while I can't speak for how USCIS is going to do it, I just don't know the details. I can tell you how it would have worked under the legislation Congress considered years ago. And that is, just as you indicated, there were non-citizens who legitimately have Social Security numbers so that they can work. That doesn't mean they're citizens. That's why what was proposed in Congress would have been a check not only against Social Security records, but also against immigration records.
Mm-hmm.
Because Social Security records can tell you if someone is a native-born citizen. Why? Because it has your place of birth. At least currently, if your place of birth is in the United States, you are by definition a native-born U.S. citizen. And for those persons who have Social Security numbers legitimately, but who were not born in the U.S., they're naturalized citizens, etc., you can use data from DHS and potentially even the State Department to make sure that they are naturalized citizens and not people who have Social Security numbers but who are not citizens. So that's why we built it into a two-phase process or two data set process in the legislation, very similar to E-Verify.
Yeah, that's what I was going to ask about, because it sounds like E-Verify, although E-Verify checks a different thing. In other words, you can pass an E-Verify check and not be a citizen, because what E-Verify is checking for is whether you're actually allowed to work. And there are people who are, obviously illegal aliens aren't allowed to work. And there are legal aliens who, are here on some kind of non-immigrant, temporary visa status that doesn't allow them to work, who also would be flagged by E-Verify. So it does check a little bit different thing, but it's the same kind of two-step process. Is that basically it?
Mark, again, you are exactly right. I have to say that
that's why I get paid the big money.
E-Verify was created by Congress in 1996. At that point in time, I worked for Lamar Smith on the House Judiciary Committee. It was his House legislation along with Alan Simpson's Senate legislation, which became the 1996 Immigration Act. And it was the very creation of E-Verify in 1996, which gave me the idea initially of seeing how this system could be adapted to serve as a voting verification role. So that it was introduced a year after the enactment of the 96 Immigration Act. It went to the House floor a year and a half after the enactment of the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. And it was that very E-Verify provision in the 96 legislation which was sort of the muse for creating this system.
Right. Just so, I have another question here, but just to clarify for people, the law, in other words, don't go searching in congress.gov for the words E-Verify in the 1996 law, because it described what the thing you're talking about as a pilot program initially. The E-Verify branding, the name, which actually is a pretty good name, came out of the Bush administration implementing that provision of the law. Is that correct?
Mark, again, you are exactly right. I think in 1996, we sort of failed Marketing 101. The name we came up with for what is now E-Verify was the quote-unquote basic pilot program, probably the worst, the least inspiring name you could ever come up with.
Right.
But that was the initial name, and to their credit, DHS came up with E-Verify.
Yeah. I'm not a big fan of a lot of what the George W. Bush administration did on immigration, but I got to say, in branding in this regard, they came up with something that worked. The question I had was that in this recent announcement that USCIS is saying it's, coming up with this system to allow states to determine citizenship for people registering to vote or people already on the rolls, they're piggybacking it on, or kind of, it's an updated version of a system that already exists called SAVE, Systematic Alien Verification for Entitlements. I think they came up with the name and then the abbreviation, and then they made up the name afterwards, which is often the way these things work. But the point of the original system that's up and running, and it's voluntary, but it exists, is for states and localities to check whether an applicant for public benefits, for welfare or other public benefits, is eligible. And can you sort of give us a little bit of background on how that came about to begin with, and then how, because that's kind of the base for this registration voters issue that we're talking about now?
Mark, exactly right. That came about with the welfare reform legislation of 1996, which was, the Personal Responsibility and Work Authorization Reconciliation Act of 1996. And welfare reform for aliens was contained in there, and some of it was also contained in Lamar Smith and Alan Simpson's 1996 legislation. And that it was in that context that the SAVE system, as you indicated, was created in order to verify that aliens were in fact entitled to receive federal welfare benefits. The welfare reform legislation put strict limits on the ability of non-citizens to receive the federal welfare benefits, food stamps, and supplemental security income, and all those sort of things.
Medicaid.
essentially certain categories of legal aliens, lawful permanent residents, people who had received refugee status, asylum, infamously parolees, as we've talked about, had the highest level of eligibility for federal welfare benefits among non-citizens. On the other hand, illegal aliens, aliens here on a temporary basis, with a tourist visa or a work visa, were not eligible for federal welfare benefits, and there had to be a method to make sure that applicants were in fact eligible, and that's where SAVE came from.
Right. So we've talked about using the Social Security Administration, essentially the identifier of a Social Security number, as the basis for checking welfare eligibility by non-citizens. And there's a recent announcement of using that system and adapting it to check voting eligibility for anybody. In other words, whether they are in fact eligible to vote, aliens or not, and to determine who is a citizen and who isn't. And so the other thing I wanted to talk about, as I mentioned at the beginning, is using this national identifier of the Social Security number to help determine employment eligibility as well. And that's something that we haven't seen any action on yet, but it may well, in fact, I would probably guess probably is taking place kind of behind the scenes in the form of reviving what are called no-match letters. If you could give us a little explanation of what no-match letters is and, how were they used in the past or issued in the past and what happened with them?
Sure. After a multi-decade effort, basically starting in the 50s, in 1986, Congress finally passed and President Reagan signed into law legislation making it unlawful for employers to knowingly employ illegal aliens and other aliens not eligible to work in the United States, but in addition to use a document check when they hire someone to make sure that their documents indicate they're legally eligible to work. That's employer sanctions. That's been the law since 1986. But as was recognized was a risk at the time, there was no effective mechanism put in place to ensure that people who weren't eligible to work could use stolen or fake documents to get through the system. The 86 system, which is still with us today, it's called the I-9 form. The employee, the new hire, has to show the employer documents showing who they were, proving their identity, and proving their employment authorization. And very soon after 1986, that resulted in a massive market in cheap fake documents, which, by the millions. And that's been the case ever since. So employer sanctions, as enacted in 1986, has been a complete failure because of the easy availability of fraudulent documents to give to the employer. And under the law, if the employer is given a document by the new hire that reasonably appears to be genuine, the employer has to accept it. In fact, if the employer doesn't accept it or asks for additional documents, the employer is liable to be charged with violating the anti-discrimination law. So it really puts employers between a rock and a hard place. And that's why Barbara Jordan and her created in 1990 Immigration Commission recommended there needed to be a secure electronic method to verify that new hires actually were who they say they were. And that's what resulted with the implementation of Barbara Jordan's recommendations was the provision setting forth what is now E-Verify in the 1996 Immigration Act. Unfortunately, it's voluntary on the part of employers, and for most employers it's voluntary, though some states have made it mandatory for some employers in their states, and federal contractors have to use it. But for most employers in the country, it's voluntary. But there is an alternate way of getting to that same level of verification, which doesn't require a new law. And in fact, this was something that the George W. Bush administration realized way back in, I think it was 2007 when it first started it. They don't do it anymore because Biden discontinued the practice, as had President Obama. But other than that, for many years, when employers send in Social Security wage withholdings for their workers to the Social Security Administration, if those workers are using fraudulent Social Security numbers, the employer is going to send that number with the withholding to the Social Security Administration. And the Social Security Administration, when it noticed that an employer had more than 10 workers who were giving Social Security numbers that didn't match up with Social Security Administration records, it would send a letter called a no-match letter to the employer saying, hey, thanks for sending in the withholdings for your employees, but these employees, as listed, their Social Security numbers don't match up with what we have. Now, there are innocent reasons why this could happen. There could be a clerical error. There could someone gets married and doesn't let Social Security know of their new official name. But another big reason is that the employee actually used a fraudulent Social Security number to get hired, and that's what the employer is sending in. So DHS, under the Bush administration, proposed this regulation that, look, employers, if you receive from the Social Security Administration a no-match letter, you're under no obligation to do anything. That's true. We can't change that. We're not the Social Security Administration. But we're going to give you a safe harbor procedure you can use to verify the employment eligibility of those workers identified in the no-match letters. If you don't have to use this safe harbor system, if you don't, you bear the risk, or you run the risk, that you're going to be found to have constructive knowledge that you were employing illegal aliens.
And that deals with the issue that a lot of employers get out of punishment by saying, look, it looked legitimate to me. I didn't know that he was an illegal alien. And sometimes that's true because, employers, as you suggested, are actually kind of between a rock and a hard place because the DOJ will come after them if they say, this looks a little fishy, you got any other ID? On the other hand, a lot of employers know perfectly well these people are illegal aliens and get away with employing them by saying, what did I know? It's sort of like Sergeant Schultz in the old Hogan Heroes sitcom. I know nothing, I see nothing. And so what you're describing here is a way to get around the Sergeant Schultz problem where they say, look, you may have seen nothing, but you just got a letter. And, it's going to be hard for you to deny that you didn't know these people were illegal aliens.
You're exactly right. And, the system we have is the worst of both worlds. It rewards unscrupulous employers who want to employ illegal aliens, and it penalizes employers who want to do the right thing, but if they take one step too far in verifying their employees. So currently, the I-9 system is the worst of both worlds for exactly the reason you state. And in any event, if an employer is found to knowingly employ an illegal alien or any other alien who is not eligible to work, there are civil penalties. And if they engage in a pattern or practice of this activity, federal criminal penalties. So that was the offer that the Bush administration made to a regulation. Of course, there was a lawsuit, and a federal judge enjoined the Bush administration's regulation, not on the merits. The judge actually said in the decision, it's rational for DHS to use a no-match letter, not as a conclusive indicator, but as an indicator that this may be an illegal alien employee. But the judge ruled on various procedural issues. The DHS had not clearly explained its change in policy, things of that nature. And so what the Bush administration did, it didn't just sit back and do nothing. It actually reissued the regulation, making the changes in order that would hopefully satisfy the judge who would enjoin the regulation. Unfortunately, at that point in time, President Obama took office. There was a lot of pressure on him and the administration from employers in industries that hire and employ a lot of illegal aliens to terminate the Bush administration's regulation. And that's what President Obama's DHS did. It terminated the regulation, so we never got a ruling from the judge as to whether Bush's Regulation 2.0, passed muster. It was just terminated by the Obama administration. So what I will recommend is that the Trump administration consider the possibility of reissuing the Bush-era regulation. And it would have to do that and two other things. One is the Social Security Administration would have to start issuing no-match letters again, which was stopped by the Biden administration. So that has to be done. In addition, current no-match letter, or not current, the no-match letters as they had gone out until they were stopped, and also even the current Department of Justice website state that if you're an employer and you receive a no-match letter, do not use that as a basis of firing an employee. If you do, you're going to be subject to the anti-discrimination laws. So right now, even today's Pam Bondi, Department of Justice, has something on their website saying, employers, you receive a no-match letter, don't do anything, you may be liable for that. So in order to get this process up and running, DHS could reissue the regulation, but then Social Security Administration, if they haven't already, and maybe they have started issuing no-match letters again, would have to start issuing them on a large scale. And Social Security and Department of Justice would have to change their advice to employers and no longer say that you taking action on the basis of a no-match letter is going to get you in legal trouble. In fact, what the Department of Justice did in 2008 after the judge's injunction against the DHS regulation was to issue a notice in the Federal Register saying, if you follow this safe harbor procedure that the Department of Homeland Security is recommending to you after you receive a no-match letter, we will find that you did not engage in discrimination.
Right.
So, there's a clear, easy way to fix this all. It's all laid out. There's not much work that has to be done, but those are the things that need to be done.
Right. And part of your third point there is not only to tell employers that, you won't be penalized for supposed discrimination, but DHS needs to lay out the specific steps you need to take to get there, the safe harbor procedure you're talking about. So anyway, and the interesting thing on the issue of the injunction at the end of the George W. Bush administration, in other words, they basically ran out of time. That really does highlight why it's important to make these kind of changes at the beginning of an administration so that the wheels of justice grind slowly. But if you do it at the beginning rather than at the end, you have a better chance of getting these things enacted. Under the Bush administration, the reason they didn't do it till the end is because until 2007, it was May or June, they had been working to pass a huge amnesty and increase in immigration, and it failed multiple times, spectacularly failed in mid-2007, and only then did they decide, okay, we need to start enforcing the law to give the public and lawmakers some confidence that all of these promises we've been making about enforcement in exchange for amnesty, that they actually believe us, because nobody believes us, and with good reason. But my point is, that's one of the reasons they had an 8-year administration, and only in the last, year, less than a year and not even a year and a half, did they roll out some of these efforts, that some of which stuck, others of which ran out of time because of judicial rulings.
Mark, you're exactly right. Whenever the Bush administration did something to vigorously enforce immigration law, it was exactly as you said, to try to convince Congress and the American people that they were serious about enforcement, so give us our amnesty.
Right. And Obama, the same thing. The interesting thing was the Biden administration, they just abandoned the pretense, and they just didn't even bother to pretend to enforce the law. It was really kind of remarkable. But one thing this whole issue of identification, of the role of the Social Security identifier in eligibility to vote, eligibility for welfare, eligibility to work, is something I actually heard at a meeting with Mike Chertoff, who was Homeland Security Secretary under George W. Bush. And it was a meeting and a bunch of us were there. And he made an interesting observation. He said he could understand the position. He didn't agree with it, but he could understand the intellectual argument for not having any identification system, that it's somehow, tyrannical or oppressive or whatever it is. He said, okay, well, I can, at least that is an intellectually honest position. He said what he couldn't abide was those who said, yes, we need an ID system, but let's make sure it's as bad as possible so that it's incapable of doing its job. And in a sense, what we're seeing, what we did see it at the end of the George W. Bush administration, to give them credit, and what we're seeing now under the Trump administration is an attempt to make the ID system that we have, and which is literally inevitable and inescapable in a modern society, make it actually work properly, as opposed to it being a kind of Swiss cheese system that both employers of cheap labor, libertarian and leftist opponents of borders and sovereignty, all of which they approve of the Swiss cheese element because they can't have what they want, which is no ID system. So they'll settle. Their compromise position is a bad ID system. And that's what the Trump administration seems to be trying to fix. So instead, we have a good, or at least better, ID system.
Yeah, I think that's exactly right.
Okay, I think that's good. We're going to have two pieces that we'll link in the show notes on these issues we've been talking about. One on the verifying voter citizenship, and one on the no match letter issue, and we'll have links in the show notes for those. So until some other development happens, George, thanks for coming on, and please keep an eye on this for us.
I sure will, and Mark, thanks so much for having me.
And finally, a few thoughts on foreign students, and this is in the news this week for a couple of reasons. One is that the president has just announced he's going to suspend all foreign student visa issuance abroad in order to be able to put in place a system to be able to vet the social media of prospective foreign students. And this has been a problem because we have been admitting as foreign students people who are, at the very least, virulent anti-Semites, but, America haters as well. And so the point is try to find out what these people are about before we let them in. Because as Secretary of State Rubio has said, we're not, we don't want to be admitting people who are here just to cause trouble rather than to get an education. The other thing, that's still kind of up in the air, and that's a kind of temporary measure to deal with this, to sort of put in place a new system. The thing that we've written about this week is about specifically Harvard's ability to bring in foreign students. And we have a couple of posts on this. It's been in the news that the administration has said Harvard is not allowed to let in any foreign students. The two posts we have on this that we'll link to explain kind of how it works, but basically a university fills out a form that says, yes, this person has been admitted to study at our university, and then that foreigner abroad takes that form to the State Department consular department and says, I'd like a visa. Here's the school that says they've admitted me. And what the administration has done is revoke Harvard's authorization to do that. But of course, Harvard immediately sued. Of course, a federal judge said, no, I know better, and the president isn't allowed to do this. But an interesting thing that we posted by Dan Cadman, who's a fellow at the center, the title is the Harvard TRO likely to be effectual? TRO meaning temporary restraining order by the judge. And you can read the thing yourself, but Dan's point is that even if the judge says, no, you all aren't allowed to revoke Harvard's authorization to let in foreign students, it's probably not going to work as the judge intends, because foreign students who are abroad are just going to be turned down by the State Department. And judges don't have any power to tell the State Department, you have to give visas to people. That's just fundamentally illegal. And this is the point I really hadn't thought of, this rule by the administration applies to current foreign students, that those that are at Harvard now are going to lose their ability to be at Harvard. So basically, we're at the end of a semester, so they're going to have to find somewhere else to go to school or go home. And the judge's freezing of that administration order isn't likely to do very much in this regard either, because how many students are going to want to live under that uncertainty and risk of maybe having to leave in the middle of a semester if depending on how the trial, if there is one, goes. And so it's likely a lot of the foreign students are going to be looking to transfer to other schools. So the point of Dan's post was that the administration likely is going to be able to de facto remove Harvard's ability to bring in foreign students, even if an activist judge decides that he knows how to do this sort of thing better than the administration, which is responsible for the issuance of visas. So we'll follow that story. I'm sure various things are going to happen. Heck, today, while you're listening to it, something new development may happen. But it's an interesting issue, and the broader issue of foreign students, because we have something like 1 million foreign students in the United States, is something that hasn't really been grappled with in the debate on immigration very much. And it affects all different aspects of the immigration issue, and it's something we are going to be talking about more in the future. But in the meantime, thanks for tuning into this episode. Thank you to Brian Griffith, our producer, for making this whole thing work, and I hope you'll tune in next week.